waiting to see the court's order. The court's order dealt with essentially the admission of lyrics. Our challenge to, it's number 26, Dennis, item number 74. Right.
Did the state find that order?
We did.
Okay.
Your Honor, we sent that order last night to court and all parties. Judge Glanfield's ruling on the lyrics.
Okay. I didn't see it in my email this morning, but maybe it's there now.
But would it be a fair characterization to say that it's the admission of the lyrics, and the court ruled on the admission of the lyrics? This is a video, and it is a video essentially with one of our co-defendants as the primary singer. And I believe it has Mr. Nichols in the background. So my challenge is not to the admission of the lyrics,
Okay.
but to the admission of the video. And I think the video should be admitted against, with all due respect, Mr. Jackson, but not admitted against Mr. Nichols. It's Mr. Jackson's video, and Mr. Nichols is in the background. And that would be like saying, if Gladys Knight and the Pips were singing, it would be admitting the actions of the Pips against Gladys Knight and that midnight train to Georgia. Not that I remember
Who's
that
who
song.
here? Jackson is Gladys and Nichols are the Pips.
The Pips, yes. Mr. Nichols is a Pip.
Okay. Well, I mean, I guess I don't know, let me look at the video, but I would think that both Mr. Nichols and the Pips are in the background voluntarily.
Before you look at the video, can I just make an observation and a comment? My client's artistic expression, I want to put this in context. My client was arrested in 2005. The state has, not until 2022, I guess, got around to trying this case. Mr. Stillwell was rapping, and he dared to say in his rap song, "I beat a murder rap, paid my lawyer $30 for that," because a reasonable person would believe that he had been arrested for murder and beat it because he had been released and no one had tried him. I have no idea how this has become some sort of admission saying I beat a murder rap, because he was arrested for murder and he did beat it. I have no idea the relevance of this. He's just stating I'd been arrested for murder, which is clearly true. And he beat it because he was out on bond. So I have no idea why this is admissible against anyone. I have no idea why it's relevant. I agree with Mr. Harvey that the fact that Mr. Nichols is in the background shouldn't come in either, but I don't believe that this should come in against my client. I think that this whole ruling is out of left field, respectfully, and that's our stance on it. I just wanted to provide that context before you viewed the video, because that's what it is. It's years after he had been arrested for murder.
When's the video from?
I don't
2019, we believe.
2019. So it's 4 years. The state says 2019. I'm not certain, but according to the state, it's 4 years after he had been arrested. He had been released, and no one had tried him on the murder, which he's innocent of. And he was merely stating, I beat a murder rap. So I don't know why any of this is coming in, but I appreciate Mr. Harvey's point that nothing came out of his client's mouth either.
Yeah, it's not an assertion under 801 D2E. So I don't see it coming in with regard to Mr. Nichols. And I adopt everything that Mr. Shart just said as well.
Is,
It's against interest either, Your Honor. It's not against any interest. It's not anything that's inculpatory.
talk into the mic because they can't hear you back there.
Good morning, Judge.
Good morning.
I'm not sure that it's against any interest. It's not anything that's inculpatory.
I think that might just be a statement by a party opponent.
All
Your
right,
Honor.
but my client made no assertion.
I'm talking about as to Mr. Jackson himself.
Your Honor, I would point the court's attention as well in response to Mr. Nichols' assertion to page 8 and 9 of the order.
Okay, I still don't have the order in front of me, so
Send it to
Your Honor, I would resend it. It was sent at 4:47
okay.
yesterday, so I will resend it right now.
I mean, I thought I perused it.
the court. Prefers still that we just send it to Ms. Percival.
I've got it.
Okay.
She's sent it.
Mr. Atkins, what page of the order were you referring the court to?
No, it was
Page
this one.
8 and 9.
All right, thank you.
You're welcome.
I'm not challenging the lyrics.
The subsection G.
Yes, Your Honor. Specifically, the court finds that contrary.
Yeah.
Oh, yes,
I
I'm
can
sorry.
read it.
Okay.
That goes to the lyrics. Yeah, that's irrelevant.
In subsection M.
M also.
Yes, Your Honor.
Okay.
I know that. I can see that.
It starts on page 27,
All right.
and then there's a section 9, Roman numeral 9. And finally, the rulings on page 41 as against Mr. Nichols. Right, the court rules of the lyrics evidence referenced in 8.
The murder case that Mr. Stillwell Jackson was arrested on and then not tried on or whatever happened, is that asserted in this indictment as an overt act?
It's count 2. And it's one of the
Oh,
overdoses.
okay. So it's the Thomas murder.
Yes.
Okay. All right. I'm familiarized myself with those parts of that ruling now. If you want me to watch the video, I will. But it appears that... Is it on Zoom? Okay, let me get on Zoom. All right, go ahead.